First of all, a little bit about me and why you're listening to me. I'm an employment attorney. I've been practicing for almost 30 years. I'm based in Maryland. I'm also licensed in DC and wild and wonderful West Virginia. It's been pretty exciting this week for us employment law geeks because the General Assembly wrapped up. So we're going to address some of the changes with that, and also that the General Assembly has enacted. And also we're going to talk a little bit about some of the fallout or changes driven by the Great Resignation of 2022, which started in 2021, but that's kind of changed the landscape. So today primarily we're going to talk about the Maryland Family Medical Leave Insurance Program, because that's going to affect every employer in the state of Maryland that has one employee. And it's quite a it's quite a detailed law that the General Assembly just passed. The governor vetoed it, but this Saturday, the General Assembly overrode the veto, so it is going to be the law of the land. We're also going to talk briefly about some changes that the General Assembly enacted in the harassment and discrimination claim realm. They did make some changes too regarding harassment and discrimination claims under Maryland law. We'll talk, like I mentioned, about the Great Resignation and some of the issues that employers are facing and addressing as a result of that. And then we will also talk briefly about protecting employer information, which really is kind of an extension of the Great Resignation. It's become more important as there's been more employee turnover and employees changing jobs and all of that good stuff. As you may know, being employers and dealing with personnel issues, the looming lawsuit is always kind of back there. And as the General Assembly and Congress and courts issue rulings and new laws, there's always that chance of more liability. So, you know, this is kind of why we try to do these things, to keep you, my job is to keep my clients and employers out of trouble for entrepreneurial plaintiffs, as I like to think of them. So, so the first thing we're going to deal with, as I mentioned, is the Maryland Family and Medical Leave Insurance Program. This is new and kind of earth-shattering for Maryland because it's the first paid leave program for family and medical leave. We have the Safe and Sick Leave law that was passed in 2018, but that really requires unpaid leave for smaller employers and paid leave for larger employers, and it was limited to 40 hours, and it was accrued over a certain period of time, or it could be front loaded. But this new law is a way more comprehensive paid leave program, and it's funded. It will be funded by employee contributions, employer contributions, and some state financing in some circumstances that we'll talk about. So that's another aspect of it that's new from prior law, is that it's going to be a separate fund, such as the unemployment fund, where claimants will apply for benefits and the state will actually pay out benefits if it determines that there's coverage. So in addition to having to provide the leave under the law, most employers, larger employers, will be paying for the leave, as will employees, whether they use the leave or not. It's a new, basically it's a tax. It is more comprehensive than the Federal Family Medical Leave Act. It covers more employees. The federal FMLA covers employers that have 50 or more employees within a 75-mile work site. This, as I mentioned, covers smaller employers, covers all employers. It covers all Maryland employers and situations. It's more comprehensive than the Family Medical Leave Act, and we'll talk a little bit about that too. And then it potentially provides more leave. The Federal Family Medical Leave Act provides up to 12 weeks of unpaid leave. This provides potentially more than 12 weeks of leave, and it's paid, as I mentioned before. So it's also more comprehensive than that, and it provides more leave than the Safe and Sick Leave Law, which was the Maryland Healthy Working Families Act that was passed in 2018. So it provides, which provided up to 40 hours of, required us up to 40 hours of leave. This is much more extensive. So as I mentioned, employers with 15 or more employees will be paying into the fund. So not all employers, the smaller ones won't be paying into the fund. All employees who make more than $15 an hour will be paid in, contributing to the fund. And also self-employed individuals who opt to participate in the fund. So if someone is a sole practitioner or a small company owner, someone who's self-employed, they can elect to participate into the fund, but there's guidelines that apply to them. So someone doesn't just jump into the fund because they know they have some kind of leave coming and then jump back out of the fund. They have to commit to a certain amount of participation in the fund. And then the state will be contributing for employees who earn less than $15 an hour. So one of the controversial things about the law and that concern the Maryland Chamber and other employer groups was how much is going to be paid, and so that's kind of been left open. So it will be based upon, in the statute, it'll be based upon the employee's average weekly wage. If it's above the state average weekly wage, they'll get a certain percentage of that. If it's below the state average weekly wage, they'll get a higher percentage. I think it was 90% that they'll receive of their wages as paid leave under the program. It will be at least $50 a week. And for the first year, employees who receive benefits will not receive more than $1,000 a week. After that, the Secretary of Labor is to determine the maximum cap based on the Consumer Price Index. And there's language in the statute that governs how that's determined, and that is definitely more CPA-ish and that's above my pay grade to figure out how they're going to work that one out. So important dates to remember. June 1st is of 2023. So a year and a couple of months, or not even 2 months, the Maryland Department, the Secretary of Labor is supposed to determine the overall contribution rate. It'll be a split between the employer and the employee. It's the range of the split will be between 25 and 75%. So the Department of Labor, the Maryland Department of Labor, really has a lot of things to do with before this law starts to be implemented. They've got to issue regulations and guidance, possibly set up a new unit. So that's why there's kind of a long lull between the passage of the law and when it'll take effect. So as I mentioned, the Department of Labor has to determine the contribution rate. And then October 1st of 2023, so October of next year, the contributions, the employer-employee contributions begin into the fund. And then on January 1st, 2025 is when benefits will begin. So everybody will be paying into the fund for over a year before it's actually benefits are available. So who's covered? Again, this for larger employers who have 50 or more employees that are familiar with the Family Medical Leave Act, which is the federal leave law. Covered employees, an employee has to work for the employer for at least 12 months, have had to work 1,250 hours. Under the state law, coverage is much broader. So a covered employee, someone who could apply for benefits under this new state law, has to have worked 680 hours over the 12-month period prior to leave. So they've had to work less hours, but importantly, you may notice that it doesn't say for the employer for under whom they're taking the leave. So under the Family Medical Leave Act, the federal law, the employee has to have worked for the employer for 12 months prior to qualifying for leave, being a covered employee for leave. Under the state law, they have to work 680 hours for any employer. So theoretically, someone can start day one and be entitled to coverage if they've worked somewhere else for 680 hours prior to needing the leave in the 12-month period. Employer under this new law is defined as a person or governmental entity that employs one or more employees in the state of Maryland. So again, much broader than the Federal Family Medical Leave Act, which requires 50 or more employees in a certain 75-mile radius. This applies to everyone, all employers, including self-employed individuals. I mentioned they can elect to participate in the program. So the situations that are covered, what does the employee, what entitles them to the leave? It's very similar, the situations, to the Federal Family Medical Leave Act and the Safe and Sick Leave law. To care for a child during the first year after birth, adoption, placement of foster care, kinship care, which I'm not quite sure what that means. It's not defined in the act, and that's not something that's listed under the Family Medical Leave Act as coverage. To care for a family member with a serious health condition. So like the federal law, if there's a family member who has what's defined as a serious health condition under the act, the employee may be entitled to leave to care for that family member. The employee's own serious health condition that would render them unable to perform their job duties. Again, that's similar to the federal law, Family Medical Leave Act. To care for a service member who's a next of kin, and any exigency rising from family members' military deployment. So in addition to covering more employers than the federal law, the definition of family member under the state law is expanded, includes grandparents, step-grandparents, siblings. So under the federal law, someone can't take leave to care for a brother or sister who has a serious health condition, or parent-in-laws. Under the federal law, it covers parents and children and spouses. And spouses are also covered by the state law, but the state law is family member, the definition is expanded to include the grandparents and siblings and parent-in-laws. Bonding leave, as I mentioned, adds kinship care, which is broader than the federal law. It applies to small employers, and employees may be covered upon hire. How much leave is available? And this is one of the aspects of this that I found troubling, especially since the act applies to smaller employers, and this will definitely be much more burdensome than the Family Medical Leave Act, which applies to larger employers who tend to be able to cover for absent employees more so than an employer that may have 5 or 10 employees. It provides 12 weeks of leave for each covered situation, which is similar to the federal, which is what the federal act requires. But if the employee has taken 12 weeks of leave during the benefit year due to a serious health condition of themselves or a family member, they get 12 weeks for that. And they may take an additional 12 weeks to bond with a new child. So if an employee has a serious health condition earlier in the year, or they're off to, they need off to help a family member with a serious health condition, take full 12 weeks for that. And then later in the year, bless you, have a child or adopts a child, or a child's placed for foster care, they get another 12 weeks for that. So, and vice versa, if they take off 12 weeks to bond with the child and then later have a serious health condition or a family member with a serious health condition, then they can take off an additional 12 weeks for a maximum of 24 weeks of leave under this new statute, which can be quite burdensome. So how do employees apply for the law or for the benefit? So under the prior leave laws, that apply to Maryland employers. So for example, the safe and sick leave law, or even the FMLA for larger employers, the employee applies to the employer, says, I need this leave. You know, they have to follow certain rules. The employer has to follow certain rules, but the employer provides the leave or determines the leave isn't available. And they decide, you know, whether they're going to require paid leave benefits to run concurrently, or if it's this under the federal law, or if it's under the safe and sick leave law. If it's paid leave that the employee's been accruing or front loaded, then the employer pays them that. So it's all the employer handles the leave. Under this, it's a fund like the unemployment fund in Maryland. So for an employee to qualify or to receive these benefits, they actually have to submit a certification to the state of Maryland, presumably from a healthcare provider, like you do under the Family Medical Leave Act. The employer may require the employee to provide a certification from a healthcare provider, certifying that the employee or the family member of the employee qualifies for leave under the law. That is, they have a serious health condition. So the employee under this new law, they have to apply to the state, submit a certification stating the date that the serious health condition commenced, the probable duration of the condition, facts related to the a serious health condition that the healthcare provider has available to them, and if due to the serious health condition of a family member, the amount of time that the employee may need off in order to render that care. So for example, you know, it may be that the employee has to take off the whole day because the person's home and they have to take care of the person. Or it could be that they need, you know, so many hours a week to take the person for treatment, or or whatever. So the certificate's supposed to identify how much leave the employee will need to care for that family member with a serious health condition. And if it's the employee's own serious health condition, there has to be a statement that they're unable to perform their job duties. So unlike the ADA, where an employee may have a disability and be able to work and need an accommodation, to qualify for this leave, like the Family Medical Leave Act, the employee's serious health condition has to render them unable to perform their job duties. And it can be intermittent leave too. There's intermittent leave under this, provided under this law, as there is under the federal Family Medical Leave Act. And if the request is for intermittent leave, the healthcare provider has to certify the expected duration of the leave. And again, the Department of Labor has to, the Maryland Department of Labor has to develop regulations to implement this law. So, so they'll be busy. So after the employee files under the statute as it's currently written, when the employee files the application for benefits, the Department of Labor must give the employer notice of the claim within 5 days. So in some circumstances, the employer may find out that the employee is seeking the benefits or seeking the leave through the Department of Labor, not from the employee. Then within 10 days, the Department of Labor has to notify the employer if the claim is approved or denied. The employee may appeal the denial of the claim through the Department of Labor administrative process and eventually through the court system, which again, there'll be regulations issued, but I anticipate that it'll be similar to the process for unemployment benefits. Obviously, because it's a state program, it will have to ensure that their due process rights, and which, so that's what that will be set up to do. There is no mechanism for the employer to appeal the decision. However, an employer can report suspected fraud. And if they do find that the employee submitted a fraudulent claim, the employee, the quote unquote punishment to the employee is disqualification of benefits for 1 year. So, I mean, frankly, I think the downside for the employee to submit a bogus claim isn't particularly grave. Now, employers can require their own notice from employees. So my recommendation would be for employers to make sure your policies are updated, requiring employees to provide notice of leave. Employers can require employees to provide 30 days notice for foreseeable leave, which is similar to the Federal Act. For unforeseeable leave, so for example, for an unanticipated health emergency of the employee or family member or someone in the military, employers can require notice as soon as practicable, which is the standard under the Federal Family Medical Leave Act. And then employers can require employees to comply with other notice requirements. So for example, if someone has to submit written notice or call in as opposed to shooting someone a text message, they can require notification standards, as long as they don't interfere with the ability to use the leave. So if someone has a written notification requirement and an employee or someone close to them is unable to provide that written notification, you can't use that to deny them benefits or to claim that they're not entitled to the leave. So the $100,000 question, how does it work with other leave? The statute specifically addresses FMLA leave, and it does permit an employer to require this leave to run concurrently with any FMLA leave. So larger employers that are covered by the FMLA, if the 12 weeks required under the FMLA can run concurrently with this leave. Keeping in mind, however, that under the state law leave, if they do use 12 weeks under FMLA and under the state law, they may be entitled to another 12 weeks. As I mentioned earlier, if, for example, the first 12 weeks was to bond with a child, and then they've used that, and then later in the benefit year, they have 12 weeks to, they have a serious health condition and require another 12 weeks leave. The statute also specifically states that the employee must exhaust all employer-provided leave not required by law before receiving these benefits. So my understanding is that during the legislative sessions in which this law was discussed and considered, proponents of the law have held the position that employees are entitled to more than the 12 or 24 weeks required by the law if the employer provides additional leave. So for example, if employer provides 3 weeks of PTO, the proponents are arguing that the employee has to use that PTO first, and then they get 12 weeks or 24 weeks after they use that non-legally required leave. So my reading of that is that the 40 hours of safe and sick leave can run concurrently with this because it's not, because it is required by law. But that's to be determined, and maybe the regulations will clarify that. So in addition to permitting the leave, there are other requirements under the law that apply to employers. Employers must provide employees notice of their rights under the law upon hire, and then annually. So again, like the safe and sick leave law and the FMLA, employers have an affirmative obligation to provide notice to employees of their entitlement to this leave, which means that your employee handbooks need to be updated, your policies need to be updated, and you need to provide that notice annually. Also, in addition to the annual, the initial and the annual notice, employers must provide notice of potential coverage within 5 days of the employee's application. So if you learn that the employee's applied for benefits, you've got to provide them notice of their rights under the law, or when the employer learns of possible coverage under the law. So to me, this means that there are no magic words that the employee must say to the employer, such as, I have a condition, or I have a situation, or I may need leave under the Paid Family and Medical Leave Act. So, but if an employer learns of facts that may entitle the employee to leave under the law, they've got an obligation to provide notice of right. So for example, employee says, my wife's about to have a baby, or we're about to adopt a baby, the employer has to provide notice of the rights, or the employer learns of an ill family member, or the employee has an illness, the employer should provide notice of the rights. So provide a copy of your policy. Similar to the Family Medical Leave Act, the employer has to maintain health insurance during the leave. So the employer can't cut off leave during health insurance during the leave. There's nothing in the statute that addressed the employee paying his or her portion of the premium during the leave, which was under the Family Medical Leave Act. So that may be addressed in the regulations. Reinstating the employee upon return from leave, the employer is required to do so unless the employee would otherwise could be terminated for cause or would result in substantial and grievous economic injury to the operations of the employer. So what does that mean? If the employee's out and during their leave, we find out that they've been doing bad things, and we find a drawer full of work that they haven't been doing, and there's cause to terminate them, then you can terminate them for cause. Or if there's going to be a layoff due to economic conditions of the company, and they would be part of that layoff anyway, then you would not have, the employer would not have to return them to the job. But otherwise, the employee is entitled to reinstatement to the same or an equivalent position when they return from the leave. And also, most importantly, non-retaliation for applying for inquiring about, testifying in support of a claim for leave, or conveying an intent to file a claim or an appeal is prohibited by the statute. So I see lots of trouble down the road when employees file for leave, and they may have other issues going on in the workplace, and kind of attempting to bind the employer's hand because this request for leave or leave is in the picture. So what if the employer violates the leave law? So the mechanism in place under the statute, an employee can't go right to court. They have to exhaust an administrative remedy. So they have to file a complaint with the Maryland Secretary of Labor, which again, the Department of Labor needs to set up a mechanism for accepting complaints and processing complaints. And they will have 90 days to investigate and attempt to mediate the claim. The secretary made an issue after they've done their investigation, an order directing the employer to pay monetary damages, to reinstate the employee if the employee has been terminated in violation of the law, and then to impose a penalty on the employer of $1,000 per violation. After that, after the secretary issues the order, if the employer does not comply with the order, then either the Secretary of Labor on behalf of the employee, or the employee directly can go and file a civil action for failure to comply with the order. So it isn't like under the federal and state statutes and some local codes where an employee, before they bring a cause of action for discrimination in the civil rights laws, in court, they have to exhaust their administrative remedies. And then if the agency finds that there's not evidence to demonstrate a violation, the employee can go and file a lawsuit anyway once they receive a notice of right to sue. This is a little different. They can only go and file a claim if there's been an order from the secretary stating that the law has been violated and directing the employer to pay, and the employer fails to pay the claim. So a lot of this will be, I believe, resolved at the agency level. If, however, and there's a lot of incentive for an employer to comply with an order, because if the secretary or the employee files a lawsuit, they can recover treble damages, so 3 times the amount of benefits that have been denied, punitive damages, which is different from the other wage payment law remedies, attorney's fees, which can often be way more than the actual wages at issue and damages at issue, cost and other relief, injunctive relief, such as reinstatement. So the court, they could seek reinstatement. So I'm going to pop up. I'm going to try to answer your questions. I see that there's some questions in the
Thank
chat.
you, Melissa. I was going to say, did you want to try to address any of these questions that have come up before you move on to your next topic?
Yeah, let me just scan through really quickly. How will this work when the employee has short-term or long-term disability coverage? That's a good question. I have seen no evidence in the statute that they've addressed this. This may do away with the need for short-term disability, but I'm just speculating. Maybe the regs will address that. But overall, I think in trying to implement the different laws, and I know that's not exactly your question, you're going to have to look at which laws apply, what the employee is entitled to under each, and then when do the laws apply? Are you complying with each law? The short-term and long-term disability coverage, we'll have to take a look at the policy and see if it is offset by any type of benefit. Maryland is not the first state to implement this type of law. I think we're like number 7 or 8. So I can take a look at how this is playing out in those other jurisdictions like New York. But that is a very interesting question. Is an employer liable for this new coverage, whether they're located in the state or not? Yes, if the employer has an employee working in Maryland, then that would apply to the employer, and the employer would be liable for this tax coverage. So the employer would have to pay the contribution, and the employee for the employee who works in Maryland. So for example, I have some, and we'll talk a little bit about this when we talk about the Great Resignation, but I have some clients that have employees in New York, and New York has a similar law. And so the employer has to make sure that they're paying into the system for the employees who work in New York, even though that they are based, the employer itself is based in Maryland. The fact that they have employees out of state means they're covered by that law, and the same would apply to this law. Sorry to be the bearer of bad news on that one. I'm not aware of any exemption for staffing agencies for this law. I have not seen anything in the statute to that effect. Again, there's going to be another legislative session before the contribution starts, so maybe it'll be amended prior to that, but as of right now, I didn't see any exemption for staffing agencies in this law. So the General Assembly was busy. They also amended the state anti-discrimination and harassment laws, similar to some other states, to make it broader than federal law. So they expanded the definition of harassment. And I just want to make clear, and I know a lot of you already know this, but there's harassment and then there's sexual harassment. Both are illegal under the state and federal and most local anti-discrimination laws. So harassment, sexual harassment is harassment related to sexual conduct or sexual issues. Harassment based on other protected factors is also illegal. So someone can be subjected to harassment based on their gender that's not necessarily sexual. And similarly, someone can be subjected to harassment based on another protected factor like disability or race or religion or national origin or any other protected factor, gender identity. So that's illegal. So they've amended 2 definitions. One, they've amended the definition of harassment, and they've eliminated the standard of severe and pervasive conduct. As long as the conduct is unwelcome and offensive, and based upon a protected factor. So general overall harassment. I'm sure a lot of you have had employees say, I've been subjected to a hostile work environment. And when you kind of peel the onion, they're not claiming that it's based on any protected factor. It's just they're not getting along with coworkers or a boss, or they feel like they're being mistreated, but it's not based on a protected factor. So the statute covers unwelcome and offensive conduct that is based on a protected factor. And the submission to the conduct is an explicit or implicit term or condition of employment, or submission or rejection of the conduct is the basis of an employment decision. So you don't put up with my harassment, so I'm going to, I'm going to give you, I'm not going to give you a raise, or I'm going to demote you, or I'm going to fire you. Or it's based upon the totality of the circumstances, the conduct unreasonably creates a working environment that's a reasonable person would perceive as abusive or hostile. So why is this change significant? They removed the standard of severe and pervasive because a lot of cases get kicked out because they don't reach that legal standard. So they changed the legal standard. So under federal law or the state law prior to this amendment, someone could say, yeah, someone, used some words that are offensive and unwelcome. They are related to a protected factor, but it wasn't severe and pervasive. It didn't alter my work environment. And severe and pervasive is a relatively high standard. So, a couple of offensive utterances weren't sufficient enough to establish a legal harassment claim. So the Maryland General Assembly decided that they didn't like that. So they've done away with the severe and pervasive level of proof required to establish harassment. That doesn't mean Title VII, which is the federal statute, that has not been amended, but under state law now, a plaintiff or an employee or a former employee can go into court and say, file a claim for harassment, and the standard is not as high to establish harassment. So what I predict is going to happen is that we're going to see more and more employees going into state court to pursue these claims because it's a lower standard to establish harassment. And frankly, state courts are more employee friendly as far as not dismissing cases on summary judgment than federal courts. Federal judges really apply the law and look at the allegations and determine whether they meet the legal standards, and they're not afraid to dismiss them if they don't. Whereas a lot of state judges are more, they don't deal with these cases as much, so they're not as schooled on them as the federal judges are, because the federal judges have seen these cases under federal law for years, and they deal with them all the time. And state judges are more likely to say, well, let's let a jury figure it out. So that's what I predict. We're going to see a lot more of these state cases. In addition, I'm hearing some feedback. Are you guys hearing that? Okay. In addition, the definition of sexual harassment has been similarly expanded. So again, they've eliminated the need for the conduct to create a severe and pervasive work environment. I'm sorry. But in the sexual harassment realm, and again, that's harassment that is sexual in nature, not based on other protected factors. Sexual harassment is a kind of a subset of gender discrimination. The conduct need not be severe and pervasive if it consists of unwelcome sexual advances, requests for sexual favors, or is of a sexual nature. And when the conduct, submission to the conduct is an explicit or implicit term or condition of employment, or submission or rejection of the conduct is a basis for employment decisions affecting the individual, or based upon the totality of the circumstances, the conduct unreasonably creates a working environment that a reasonable person would perceive as abusive or hostile. So again, it's eliminating that higher standard that the employee or former employee have to show that the conduct was severe and pervasive. in order to proceed with these types of claims. In addition to expanding those definitions, the General Assembly also they've amended the statute to toll the statute of limitations for discrimination claims during the pendency of an administrative charge. So as a prerequisite to filing a discrimination lawsuit under federal, state, and local laws, the employee or former employee has to go to an agency and file a charge of discrimination. And give the agency an opportunity to investigate the charge. And if the agency determines that there has been a violation of the law, they may, order. First they have to try to conciliate it, which means come up with a settlement of the claim. And if absent that, they can issue what's a notice of right to sue. And at that point, the employee can go and file a lawsuit under the federal or the state law. Under the state anti-discrimination and anti-harassment laws, the statute of limitations for filing a claim for 2 years is 2 years for a discrimination claim and 3 years for a harassment claim. Well, as of October 1st, the statute of limitations will be tolled while the charges of discrimination are pending. Why is this a big deal for employers? Because agencies can sit on those charges for a very long time. And at that point, you've got witnesses that are no longer employed with the employer, or some pass away. Information can disappear. It becomes a lot harder to defend a claim when it's several years old. So, so tolling the statute of limitations really can create a 4 or 5 year statute of limitations, depending on how long the charge sits at the agency. So I don't see any questions in the chat on those issues. So let's talk a little bit about the Great Resignation and some of the employer issues that have resulted because of that. I mean, I don't know, I don't think I have a single client right now that's not desperate for employees and having issues with hiring employees and retaining employees. The job, as I'm sure everybody out there knows, there's a labor shortage at all levels of the labor spectrum. And employees have been, because of COVID and the opportunity to work remotely, a lot of employees have been reevaluating their careers and their choices, and labor shortage is also creating opportunities for people that they didn't have before, because employers are considering folks that don't have the exact experience that they're looking for, but they're willing to give someone else a try that might have a different skill set, just because it's so hard to recruit. So as a result of all of this, there's a lot of movement. So here are some of the pitfalls for employers as a result of all of this. A lot of employers now since COVID has started, are hiring remote employees, or employees who now are working remotely are moving out of state, working from other places, and that can create havoc. And it goes back to that question in the chat about the Maryland, paid family medical leave law. If I have an employee that works in Maryland, does it apply? Yeah, but also if you've got employees working in these other states, like the state of New York, their laws apply as far as leave entitlement in particular. California, for example, if you've got employees in California, there's a whole plethora of laws that apply to California employees that are different than Maryland laws that apply to Maryland employees. So for example, in California, if someone is terminated or they resign with 72 hours notice, you have to pay them on their last day of work for all the wages that they're entitled to until that day. And there can be quite substantial penalties for dropping the ball on that. So hiring remote employees, you have to be very careful. It's to the point where I have to ask my clients who have employees in other states, what town and what city do they work in? Because San Francisco has its own set of employment laws that apply to employees that work there. So if you've got remote employees who work outside the state of Maryland, you need to make sure that you're aware of all the laws that apply to that employee. Additionally, even within the state of Maryland, if you've got remote employees, say, that work in Montgomery County, they've got more generous benefits for employees that are required by law than other states within the state of Maryland. So frequent turnover, there's an increased chance of making errors. And what kind of errors can occur, especially if you're working in a rapid environment where you're making offers quickly because you don't want that candidate to get away, or if there is a lot of turnover and your HR function may be a little more hectic than usual, particularly with COVID and all the various issues, because people still are calling out with COVID and working remotely, and there's just a lot of change out there. So there's increased chances that you're going to make a mistake. So for example, hiring employees, are you aware of and making sure that you're complying with the more recent Maryland laws, where if an employee requests a pay range for the job that they're applying for, you've got to provide them a salary range for that position. So for example, you go, if you go on Indeed now, or LinkedIn, and there's job listings, there'll be a little question there. Would you like a pay range for this position? And that's why, because some states like Maryland now require employers to provide a pay range if they're requested. Additionally, background checks, if you're running background checks, if you're the type of business that requires a background check, are you doing it properly? You've got to make sure you're complying with the Fair Credit Reporting Act. You're giving proper notice to employees when you're doing the background check. You're following certain procedures when you're doing the background check. And also an error that I see sometimes is an employer will get the authorization, start the background check, and start the employee before the background check comes back, and oops, there's something on the background check that makes that person ineligible or questionable for employment. And then you're in a bit of a pickle as to what to do, and especially if you haven't properly followed the procedures for running the background check. Drug testing, you've got to be careful. Maryland has very strict procedures for drug testing. Don't drop the ball on that one because you're in a hurry, or things are a little more chaotic than usual because of the frequent turnover. So on that end, you got to be careful. On the other end, when people leave or you fire employees, you've got to be careful that you're compliant, you're not making mistakes. So for example, if you have the employee in California that's leaving or that you're firing, make sure you pay them on the last day. And there are certain, for that particular law, if the employee gives 72 hours prior notice, you have to pay them on the last day. But if they don't, you get, I think you get 72 hours after they leave. But laws like that, you got to make sure that when someone leaves that you're complying with the laws for termination too. It's a lot of time. Okay. In addition to making mistakes, when there's a lot of turnover, you also have an increased risk of legal claims, which is logical. People who leave may be less inhibited to file a claim against a prior employer because they know they've got lots of other job opportunities out there and they're no longer with the employer, and there's job security and there's potential money there if they pursue a claim. So make sure that, again, that you're not making mistakes, making sure you're complying with the wage payment and collection laws, you're paying employees. In Maryland, it has to be on the next scheduled payday. If there are bonus or commission issues, making sure you're addressing those appropriately, because former employees have motivations, incentives to go after employers. And we are seeing increased claims. The statistics are showing that the legal claims are going up. Another issue, and this has been a problem too that's been emerging, is with the frequent turnover, you have to worry more, and there's more of a chance of misuse of trade secrets and confidential information, and customer goodwill. So the trade secret in particular, the more digital we become, the easier it is to misappropriate trade secret information, because a lot of it's stored digitally. We've moved away from the olden days back in like when I started practicing law, where most information was stored in file cabinets and paper files. Now information is mostly filed in electronic format now, and it's easy for someone to email themselves information, or to pop in a thumb drive and download information, or access things through the cloud. So that's been a huge issue that's emerged as a result of all of this turnover with more frequency. And that leads me into the next and final topic, is protecting that employer information. Again, in the digital era, it's becoming it's easier to misappropriate that information. So the best practices for employers to have, and the first one may seem like a no-brainer, but I think it's still a big problem out there with a lot of companies, is limiting access to confidential information to those with the need to know. Everybody in your company doesn't need access to all of your information. In smaller companies, this tends to be a bigger problem. It's easier to let someone pop into a database or have access to things when you're a small company and everybody's working together. But you really need to consider, one, what is confidential information that you don't want your competitors or the general marketplace having access to? And also, who within your organization really needs access to that information? When employees are departing, which is happening with more frequency now, make sure those employees return all employer property. And that used to mean returning your laptop or the company car, but now that may include passwords and thumb drives and access to information, not just physical things, but actually data, digital information. Change locks and passwords to the company premises and various systems within the company. So, and again, think about all your, and this really does require pre-planning. That's something you should be considering now, not when the employee is out the door or after departure, or after someone started working with your company. You need to think about all the systems now, because we have so many more systems now that are accessed remotely and digitally, from the HVAC system to access to the building, to access to all your computer systems and information. So think about the various things that the company owns and property, and make sure that when employees leave, that you do change passcodes and limit access to that information. Make sure you have employees sign confidentiality agreements and possibly other restrictive covenants when the employee leaves, such as non-solicitation and non-interference agreements, so they can't go out and solicit your clients or coworkers or important vendors after they leave. And the agreements, the Maryland law with regard to restrictive covenants, such as the confidentiality agreements and the non-solicits and non-competes, has been evolving. Courts have issued opinions, and those opinions become precedent, and your agreements need to comply with those changes. So make sure that you're having your agreements updated and they are compliant with the current state of Maryland law, if Maryland law applies. You can, unlike these other laws that apply to employees remotely, that statutes that you have to apply to employees that are in those remote locations, your agreements with them can be governed by Maryland law if there's a nexus to the state. And if you're a Maryland-based employer, then there's a nexus to the state, and the agreements can apply Maryland law. But if for some reason your employees have agreements that apply different state laws, make sure those agreements are updated to comply with those different state laws. Now, also, one thing to keep in mind with these laws, non-competes are becoming increasingly disfavored, both by legislatures and courts. They're harder to enforce, which is why it's important if you have to have a non-compete for your company, that they are updated. So for example, in Maryland, the General Assembly a couple years ago passed a law that prohibits non-competes. The non-competes are void as they apply to employees who make $15 or less an hour, or the salary equivalent, which is 30-something thousand, I believe. Other jurisdictions such as California, they outlaw non-competes. The District of Columbia, you may have heard, for a couple years now, has had a law prohibiting non-competes. It hasn't been implemented yet. And in that law, part of the issue with the delay, so if you have employees in the District of Columbia, if your agreement applies District of Columbia law, you may want to reconsider that. But the District of Columbia law actually precludes employers from prohibiting employees from working for competitors while they're actually employed with the employer. So an employee can go and work for a direct competitor. The moonlighting laws or agreements are illegal under the law. So eventually that law in some version will become effective. It's just a matter of what version. But as of right now, I wouldn't advise having a non-compete under District of Columbia law because they are void. They will be void in the District of Columbia. So it's
Melissa,
yes.
we're running out of time.
I'm sorry.
That's okay. That is very interesting. There is one more question that I don't know if you have the chat up, but I'll put it out there. As to NDAs, if confidentiality is included in the employment agreements and or employee handbooks signed by employees, should employers also have separate NDAs signed, or is that not necessary?
It's not necessary if you've got an employment agreement that includes that. Again, though, if you have an employee who, so for example, makes $15 or less an hour, you can't have the non-compete, and I would recommend just having a separate agreement that wouldn't include it. So if that employee doesn't otherwise have an employment agreement, I would have a separate confidentiality agreement for that. But if there's a confidentiality agreement, typically these agreements, and again, that's why you need to have them reviewed. Typically these agreements have a provision in there saying if any part of this agreement is deemed unenforceable by a court, the remaining part, it'll be stricken and the remaining parts are enforceable. So for example, if the employment agreement has a non-compete, the court decides that the non-compete's not enforceable because it's overly broad, they'll strike that, but they will enforce the confidentiality agreement. And courts are much more view confidentiality agreements much more favorably than they do these other restrictive covenants. So you have a much better chance of having those enforced. And one final thing I recommend is make sure when employees are departing that you remind them of their obligation under these agreements. So they are aware that they're still out there, because a lot of employees will say, oh, I never signed anything. And then lo and behold, when they started, the onboarding process, they were signing lots of things and they did sign an agreement. So it's good when they leave to remind them of their restrictive covenants and even give them a copy of it. Thank you for joining me today. And I apologize for running over, but we just had so much information to share. And if you have any questions or follow up, feel free to shoot me an email or give me a call. That's my direct line there. Thank you so much, everyone. There's something else in the chat. Oh,
Yeah.
okay.
Thank you.